It is a great pleasure to welcome you all to this year's annual lecture of the LLM in Immigration Law Specialism at Queen Mary University of London. To those of you who do not know me, I am Dr. Niovi Vavula. I'm a lecturer in Migration and Security here at the School of Law of Queen Mary University of London. And for this year's edition, we are holding, as always, our annual lecture of the LLM in Immigration Law in collaboration with the Criminal Justice Centre of Queen Mary University of London. Apologies. So for our lecture, so since the launching of the LLM in Immigration Law, which is basically one of the few LLM specialists in immigration law worldwide, we have had the honor and the pleasure to invite high-profile leading scholars and practitioners in immigration law from all over the world to deliver a lecture in a topic of their expertise. So far, we have hosted in person Professor Vincent Chetaille, Professor François Crépeau, then UN Special Rapporteur on the Human Rights of Migrants, MS Catherine Woolard, General Secretary of the European Council on Refugees and Exiles, and most recently in late 2019 and before COVID, Professor Tendai Asume, who is the UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. Unfortunately, COVID restrictions have prevented us from holding this lecture in person, or earlier in this academic year, we were hoping we could hold it in person. Unfortunately, we cannot, but it has also enabled us to reach out to so many more colleagues and friends from all over the world who may not have been able to join us in London otherwise. For this year's annual lecture, we are truly delighted and honored to welcome Professor Siobhán Mullally, established Professor of Human Rights Law and Director of the Irish Centre for Human Rights at the National University of Ireland, Galway, and of course, UN Special Rapporteur on Trafficking in Persons, especially in women and children. Professor Mullally's CV is very impressive. From 2012 to 2018, she was a member of the Council of Europe Greta Group, and from 2014 to 2019, Professor Mullally was a commissioner of the Irish Human Rights and Equality Commission and member of the Good Friday Agreement treaty body, the Joint Committee on Human Rights of Northern Irish and Irish Human Rights Commissions. Professor Mullally's research has been published in leading journals, and her books include two of these are Gender, Migration and Care, Law and Practice, published by Routledge in 2015, and Gender, Culture and Human Rights, Reclaiming Universalism, published by Hart in 2006. She has also published a number of reports, some of which include a report published by the International Bar Association in 2019 entitled A Child Rights Response to Child Migration and Migrant Children at Risk, and a report into the independence of the judiciary in Pakistan, also published by the International Bar Association in 2007. Professor Mullally's lecture is entitled Trafficking in Persons, Rights and Punishment, Examining the Nexus with Counter-Terrorism, and it will be followed by a Q&A session. So feel free to post your questions on the discussion box, or feel free to raise your hand after the end of the lecture to pose your questions directly to Professor Mullally. Without further ado, Professor Mullally, I would like to thank you once again for accepting our invitation and for taking the time to deliver the annual lecture of the LLM in Immigration Law. The floor is yours.
Thank you very much, and I'm delighted to join you and to have this opportunity to speak to students, colleagues in different parts of the world, and in particular those on the LLM and immigration law at Queen Mary. So thank you very much for this opportunity. I was going to begin first just to say a little bit about my mandate as Special Rapporteur on Trafficking in Persons, a little bit on the modalities of work, and some of my priorities for work as the Special Rapporteur. And then, as Niovi said, I will speak in a little bit more detail around a topic that is the subject of my upcoming report to the Human Rights Council, and also in part will be dealt with in my report to the General Assembly in October. So it's touching on some of those themes, and I'd be really delighted to hear your comments, have any questions at the end also. So first, just to note, in relation to my mandate, it does have a gender dimension. It is trafficking in persons, especially women and children. That is a specific focus, but it is all-inclusive. And one of the things I'm keen to highlight in relation to trafficking in persons and the gender dimension is that we often overlook or sometimes do not fully recognize the obstacles that arise in identifying and ensuring effective referral for protection of men and boys who may be victims of trafficking. So it's quite broad, it's inclusive, and it includes all forms of exploitation. Again, with regard to trafficking in persons, international law, policy and practice on trafficking in persons has primarily focused on trafficking in persons for the purpose of sexual exploitation, and within that has primarily focused on women and girls as victims. That in itself may be sometimes problematic in triggering a kind of protective impulse or response that sees women and girls as victims only and doesn't recognize their agency as subjects, as claimants of human rights, and also poses obstacles for those who don't fit into the category or stereotype of the ideal victim. And that in turn has consequences for men and boys, for gender minorities and others who don't fit into these kind of dominant categories that we tend to focus on in thinking about law and policy on human trafficking. Just in relation to my mandate, I was appointed last August. It's a 3-year appointment, can be renewed once. And in terms of the thematic priorities that I have identified for my work, these include initially trafficking in persons in conflict and humanitarian settings. And part of the reason for that is just that trafficking in persons as such is often overlooked in conflict situations or in humanitarian settings where you've large movements of people. The tools and the responses around identifying potential victims or risk situations for children, ensuring access to protection, those are often missed, surprisingly. And again, given that international actors, UN agencies, humanitarian actors tend to work in silos, we see that trafficking in persons tends to fall into the gaps in terms of a protection response, and particularly in relation to effective prevention actions. To give an example, if we look at the current situation in Tigray, for example, where you have a conflict situation, where you have large numbers of people forcibly displaced, large numbers of children displaced and separated from their families, you would expect that this would be recognized as a situation where there are risks of trafficking, including for the purpose of labor exploitation, recruitment into armed groups, and often targeting of children. But we see very little attention to that in the responses. So I'm hoping to address that and to make links with different kinds of actors working with the Global Protection Cluster, for example, also on trafficking in the context of internal displacement. I also want to focus on trafficking in migration situations, and specifically labor migration and labor exploitation, and there to look at harder to reach sectors, sectors that may sometimes be overlooked in fisheries, for example, agriculture, domestic work. And I'm keen across my work to ensure that there is a disability inclusive response and recognition of the specific issues that arise in ensuring reasonable accommodation of trafficked persons with disabilities, and ensuring that all of the rights protected under the CRPD, the Convention on the Rights of the Persons with Disabilities, are also implemented in the context of anti-trafficking actions to ensure effective access to justice, participation in justice proceedings, recognizing particular risks that might arise in institutionalized settings, for example, or the consequences of discrimination and stereotyping that may lead to certain groups of people with disabilities being at heightened risk of exploitation. So since my appointment last August, I have been keen to work closely also with the treaty bodies and have met with all of the treaty bodies, have addressed the CERD committee and the Committee on the Rights of Persons with Disabilities, and also made a number of submissions to treaty bodies, to CERD on racial profiling, to the Committee on the Rights of the Child, on child rights in the digital environment, to the Committee on Migrant Workers on detention and rights of trafficked persons. And again, my intention there is to try to ensure that all of the human rights treaty bodies are engaging with issues around trafficking in persons, so that international law responses to human trafficking move beyond the kind of narrow focus on criminal justice and criminal law responses, so that the wider kinds of rights issues around racial profiling, for example, and racial discrimination are also recognized as being relevant in the context of human trafficking. In relation to the modalities of work, as a special rapporteur, I'm part of the special procedures branch that you may be familiar with. Within the UN system, we are independent rapporteurs, not UN appointees or members. And we operate in a range of ways through the thematic reports, through country reports and country visits. Unfortunately, not happening at the moment, but we hope to resume those soon. I had an upcoming country visit planned to Mexico, but that is being delayed at the moment. And the country visits are really important to see what's happening on the ground and to engage with civil society and NGOs. And the other main way of working is through the communications procedures. And these are set out on the website of each of the special rapporteurs. They can be quite informal in terms of individuals or NGOs contacting a special rapporteur, making a submission. It should be as precise and detailed as possible in terms of setting out individual violations, if it relates to individual violations, or it may relate to a pending policy or discussion at domestic level. For example, in the UK context, the ongoing issue around domestic worker visas and the limits on those. We can only respond when we receive those communications. We have to verify that they are credible, reliable, objective sources. And then we can respond by writing to the government authorities. It can be an allegation letter, it can be an urgent appeal, which becomes public more quickly, or it can be what's called an other letter, which is a comment on a piece of legislation or a policy issue. And that becomes public immediately and is an intervention into a policy debate. So those are the kinds of modalities of working, that is part of the everyday work of the mandate holder. I think an important development within the special procedures, and we just had a meeting this afternoon to discuss this, is that the special rapporteurs are cooperating much more together, issuing joint statements, responding jointly to communications, sometimes issuing larger, more general statements. And that, I think, is really important in emphasizing the collective force of these special procedures and ensuring that commitment to multilateralism, in particular when one special rapporteur or independent expert or working group may come under attack, or their credibility or authority may be questioned. So that, I think, is really important, having more collaboration and more joint working across the narrow silos of individual mandates. And of course, it reflects the intersections of different forms of discrimination and human rights violations also. And there will be an interesting event actually next week, jointly with a number of special procedures and independent experts, talking about that collaborative way of working, which I think could be quite interesting. So I'll post information on that as well. But I'm going to move on, and I'm happy to talk about any questions that arise in relation to those methods of working which can be quite interesting. But I'm going to move on now just to the specific topic of the lecture. And again, I'll keep it brief. Much of what I'm going to talk about is published in my upcoming report to the Human Rights Council. So it's looked at in more depth there, but I'll keep this lecture really for the purpose of highlighting a few key kind of questions and developments, specifically in relation to what's known as the non-punishment principle in international human rights law and international trafficking law, and thinking about what punishment means. So I have a few slides, so hopefully I'll be able to share these. Is that working? Great, okay. So looking at the nexus with terrorism, counter-terrorism strategies and initiatives. And really the non-punishment principle in itself, it's not found in the Palermo Protocol, the UN Trafficking in Persons Protocol. It's not stated there, but it is considered to be implicit within the object and purpose of the protocol, which is to protect the human rights of victims of trafficking. And punishment in itself, punishment of a victim, marks a rupture, a break with the commitments that have been made by states to recognizing the priority of victims' rights to assistance, to protection, and to effective remedies. So at its core, the non-punishment principle is aimed at ensuring that a victim of trafficking is not punished for unlawful acts committed as a consequence of trafficking. Now, as you can see, there's a lot there that can be unpacked and that has been the subject of extensive case law. But that is the core essence of the principle, to protect the human rights of victims. And given the trauma that has already been endured, and also the fear of reprisals by traffickers, by trafficking networks, the added fear of prosecution and punishment where an offence has been committed, is a further obstacle to victims seeking protection, assistance, and also access to justice. Punishment, of course, also undermines the fight to combat impunity for trafficking in persons because it is targeting victims rather than perpetrators. So it limits the effectiveness of investigations and the promise of accountability. And this has been quite important already in presenting. When I presented at the General Assembly in October last, there were questions specifically on part of the report, which was on non-punishment. And this was the concern that in the context of human trafficking, there is this focus on accountability, on a criminal justice response, and that is not incompatible with the human rights-based approach, because accountability, of course, is part of the human rights-based approach. But if you're prosecuting victims and punishing victims, you're missing that goal, if you like. We see references to non-punishment in several Security Council resolutions, in the CEDAW General Recommendation number 38. And the difficulty with the failure to respect the principle of non-punishment is that it also leads to further serious human rights violations. For example, arbitrary arrest and detention, forced returns and refoulement, arbitrary deprivation of citizenship. It can lead to debt burdens arising from the imposition of fines, for example, linked to immigration offences or offences for engagement in prostitution, for example, in some jurisdictions, and of course can also lead to unfair trials. And ultimately, punishment denies the possibility of recovery and is a denial, as I said, of access to justice. The Global Compact on Migration itself calls on states to facilitate access to justice and safe reporting of trafficking without fear of detention, deportation, or penalty. But despite these repeated calls that we see in many instruments, implementation of the non-punishment principle at state level remains weak, and the scope and content of the principle remains contested. As I said, it's not in the Palermo Protocol. It is considered to be implicit in the object and purpose. And the first textual reference that we get is in the Office of the High Commissioner, Principles and Guidelines for Human Rights, and human trafficking. However, since then, we see it arising in many instruments, including, for example, in the Protocol of the Forced Labour Convention of 2014. And we see repeated references to the non-punishment principle in the work of UN human rights treaty bodies. Just to give examples, and when I do give examples, I always have to say that these are being selected just as illustrative examples, not as a comment on any particular state. But if you look, for example, at CEDAW's concluding observations on Saudi Arabia, there the committee was quite critical of the fact that victims of trafficking were sometimes arrested, detained, and deported for unlawful acts committed as a consequence of being trafficked. In 2019, the Committee on the Rights of the Child urged Australia to ensure that all children subject to any form of sexual exploitation, sale, or trafficking were treated as victims and were not subjected to criminal sanctions. And several regional instruments do now include a specific reference to non-punishment, including the Council of Europe Convention on Action Against Trafficking and the ASEAN Convention. And of course, we have the recent judgment of the European Court of Human Rights, the VCL judgment, which found that the non-punishment principle was implicit within and included within Article 4 of the European Convention on Human Rights. The African Committee of Experts on the Rights and Welfare of the Child has repeatedly invoked the non-punishment principle and called on states to ensure that children who are trafficked for the purpose of forced criminality, for example, are treated as victims and are not criminalized. Now, just to move on then and to highlight the ways in which the non-punishment principle links in to other human rights obligations. And this is just a quick selection, but the principle of non-punishment, for example, is clearly linked to the obligation of due diligence, and the due diligence obligation in trafficking law was the subject of a thematic report by my predecessor, Maria Grazia Giammarinaro, and it's relevant in particular in relation to due diligence in the exercise of prosecutorial discretion. So early identification, prompt assessment by trained and qualified individuals is essential to ensuring the effective implementation of states' obligations of non-punishment. And mere allowance for mitigation in sentencing would not be enough to ensure compliance with the due diligence obligation and its links with non-punishment. Also critically important and overlooked in much of the policy documents and various reports on human trafficking is the obligation of non-discrimination. That the principle of non-punishment must also be applied without discrimination. That is critically important, of course, in the exercise of prosecutorial discretion. But what we see is that those who are often at heightened risk of punishment, whether due to reasons of race and ethnicity, migration status, or gender, are also often those who are at heightened risk of trafficking and re-trafficking. And here we see that the intersections of gender, race and ethnicity, migration status and poverty are very visible in the failures to implement the principle of non-punishment and in the contestation by states with regard to its status and the scope of its obligation. And the obligations that arise in international human rights law to eliminate direct, indirect and structural racial discrimination are particularly relevant here. The Office of the High Commissioner for Human Rights, the recommended principles and guidelines on human rights at international borders provide that measures taken to address irregular migration or to counter terrorism, human trafficking, or migrant smuggling should not be discriminatory in purpose or effect, including by subjecting people to profiling. This has been highlighted also by UNODC in its commentary on the UN rules for the treatment of women prisoners and non-custodial measures for women offenders, highlighting the overrepresentation of foreign nationals in criminal justice systems in many countries, including of trafficked women who often find themselves detained behind bars, having been convicted for crimes against public morality, for engagement in prostitution, or for breaking immigration rules, although they themselves are often victims of the crime of trafficking. The intersection of disability and human trafficking is an area, as I said, that has been neglected in law, policy and practice. The CRPD, the Committee on the Rights of Persons with Disabilities, has highlighted the impact of harmful stereotypes, discrimination, and lack of procedural and reasonable accommodation on access to justice and to remedies for persons with disabilities. And that applies also with regard to the non-punishment principle. What steps are being taken to ensure that a disability inclusive approach is in place with regard to ensuring engagement in criminal proceedings and non-discrimination in the application of the principle. It's particularly urgent where persons with disabilities may be at heightened risk of exploitation, including for the purpose of forced criminality. Now, in relation to the VCL and AN versus UK case, there, of course, the European Court of Human Rights emphasised that prosecution may conflict with the state's duty to take operational measures to protect a victim or potential victim. And that obligation is triggered wherever there is a credible suspicion that an individual has been trafficked. And here the court pointed out, and this is their words, that it was axiomatic that prosecution would be injurious to a victim's physical, psychological, and social recovery, and could potentially leave a victim vulnerable also to being re-trafficked in the future. And the court importantly recognized the link to Article 6 of the European Convention on Human Rights, and specifically the right to a fair trial, noting that as a consequence of the state's failures of identification, protection, and non-punishment, the applicants in this case, who were both children at the time that they were apprehended, were prevented from securing evidence critical to their defense. And the court pointed out that it was the state's positive obligation to identify victims of trafficking. It could not be argued that it was the defendants, especially given that they were children, who were at fault in not informing the police or legal representative that they were victims of trafficking, and this had been argued as part of the proceedings. So the non-punishment principle was recognised as being essential to the right to a fair trial. Here also, though it wasn't discussed in the court itself, I think it's important in the context of this case, again, to recognise the gender dimension, the fact that it was adolescent boys who were punished and prosecuted here, who were not initially identified as victims of trafficking, and even where they were, the prosecution continued. And there, the obstacles, as I said, to boys and to adult men in terms of being recognised as victims of trafficking, in terms of being formally identified, and also the relevance in how prosecutorial discretion is exercised is important here, and the intersections of gender with race, ethnicity, and migration status. So just to move on then to look at what is often most contested with regard to the principle of non-punishment. And that is, what is its scope and application? Does it apply to all criminal offences? What is the scope of this term, unlawful acts? And I have argued, and others have argued also, that it must be understood broadly to include criminal, immigration, administrative or civil offences, and not only status-related offences. And limiting the application of the non-punishment principle undermines the object and purpose of the human rights-based approach and of international human rights law. The CEDAW committee has been quite clear that non-punishment includes non-punishment for irregular entry or stay, and unlawful activities is the term used, that it includes a range of activities beyond criminal activities. This has been repeated by others, including OSCE. And just to give a snapshot of some of the human rights treaty bodies, the Human Rights Committee, for example, in commenting on Kuwait, was critical that anti-trafficking legislation did not provide protection from prosecution for victims who fled an abusive employer's residence without permission and who were at risk of arrest, detention and deportation as a result. The Human Rights Committee has also called on Poland to introduce into its penal code a provision to ensure that victims of trafficking are exempt from prosecution, detention or punishment for activities that are a direct consequence of their situation as trafficked persons. They've also called on Kazakhstan to refrain from charging victims of trafficking brought into the country with having violated immigration rules and forcibly repatriating them. Another point that has come up in particular in discussions in the South Asian context are restrictions on movement that are imposed on victims of trafficking as part of a sort of protective response, but one that is also quite punitive, where restrictions on movement amount to a deprivation of liberty, then the obligation of non-punishment may also be engaged. And here, this is looked at in the context of Rule 66 of the UN rules for the treatment of women prisoners and non-custodial measures for women offenders. And this form of protective custody can include, for example, requirements or detention in closed shelters where victims of trafficking may be required to surrender personal belongings, money, documents, telephones, and submit to a wide range of rules governing their conduct, with punishments imposed for non-compliance. And again, that has been argued to come within the scope of the non-punishment principle. And I should just note here also the relevance of Article 31 of the Convention relating to the status of refugees, which protects refugees from being penalised for illegal entry and presence. And that, of course, is also applicable to trafficked persons who may be entitled to refugee status or to other forms of international protection. And linked to this is the whole question of whether a failure to provide assistance and protection comes within the scope of non-punishment, a transfer, for example. And here, I'm just noting that the Council of Europe group of experts, GRETA, the group of experts on action against trafficking, the treaty monitoring body, they have repeatedly criticised states parties to the Anti-Trafficking Convention of the Council of Europe for applying the Dublin Regulation and Dublin Transfers to victims of trafficking, contrary in their view to the obligation to assist and protect such victims. Now, what I want to just spend a little bit more time commenting on is the question of serious criminal offences, whether the non-punishment principle applies. And here I have argued, Council of Europe group of experts has argued also that the non-punishment principle is limited, its effectiveness is limited when it is undermined by being applicable in law or in practice to minor offences only. So GRETA, for example, has called for the removal of exceptions. The OSCE recommendations have said that the duty of non-punishment applies to any offence so long as the necessary link with trafficking is established. And difficulties can arise where forced criminality as a purpose of exploitation is not explicitly recognised. And that can lead to difficulties also then in the application of the non-punishment principle. Looking at the situation of armed conflict and post-conflict situations, just to note that the Secretary General on Children and Armed Conflict has highlighted states' legal obligations not to doubly victimise children who have been abducted, recruited, used and exposed to violence at an early age. And trafficking in situations of armed conflict and in post-conflict situations has been referenced in a series of Security Council resolutions now, Resolution 2388, 2017, 2427, 2018, where the Security Council has called on states to ensure, for example, that children who are associated or allegedly associated with non-state armed groups, including those who commit acts of terrorism, are treated as children and are handed over to civilian child protection actors, and highlighted the importance of a focus on child protection, on rehabilitation, reintegration of children as alternatives to prosecution and detention. And as I noted, that is the approach also taken by the African Committee on the Rights and Welfare of the Child. It's also the approach taken by the Committee on the Rights of the Child under the CRC and under the optional protocol to the CRC. And again, here the argument is that children detained for association with armed groups, including designated terrorist groups, should be recognized as victims of grave violations of human rights and humanitarian law, and should be treated as such, as victims. Now, part of the question that is linked to this then is what forms of punishment are covered. And here I have argued in my report to the Human Rights Council, and we have argued in a number of statements from joint communications from the special procedures, that a wide range of forms of punishment are prohibited. So, for example, concerns in relation to the separation of children from parents in the context of ongoing conflict and the limited repatriation of citizens from camps in northeastern Syria come within the scope of states' obligations on non-punishment. And where punishment includes the separation of a child from his or her parent or guardian, then the child's right to family life is engaged, and that includes the right not to be arbitrarily separated from a parent or guardian. A range of other forms of punishment arise that are also engage the non-punishment principle. This includes deprivation of citizenship, exclusion from refugee status, denial of welfare benefits, separation of families, and refusal of consular assistance. And here we know that the prohibition of arbitrary deprivation of nationality, for example, is a norm of customary international law, and of course has a very troubled history, is rooted, as I've noted there in the quote, in histories of racism, positioned at attempts to exclude and limit the application of human rights law on discriminatory grounds. So deprivation of nationality in itself is a form of punishment and administrative sanction that violates the non-punishment principle, but also increases the risk of re-trafficking. And here I would like to note the work that has been done by Statelessness Institute and others, highlighting the risks between statelessness and heightened risks of trafficking. The Committee on the Rights of the Child has also expressed concern here specifically in relation to the situation of children. And this also brings up the question of whether and how the obligation of non-punishment applies extraterritorially to identified or presumed victims of trafficking. And here I have argued, and we've argued in communications to states, that states are required to fulfill their positive obligations to take protective operational measures to ensure non-punishment, including by seeking to end detention or other restrictions on liberty or other forms of punishment, and also providing consular assistance and ensuring repatriation. And repatriation itself is one of the few strict legal obligations, in fact, imposed by the Palermo Protocol. So those will be the subject of some discussion in my report to the Human Rights Council in 2 weeks' time. And they are the subject of ongoing communications with now 58 different states, jointly with the Special Rapporteur and Counter-Terrorism and several other special procedures. But part of the intention behind that was to highlight the intersecting and overlapping human rights issues, and to ensure that there is a recognition of the ways in which obligations under law relating to human trafficking may be triggered, may be implicated. So just to conclude then, I want to note and just reflect on some of the concerns around how laws relating to human trafficking operate and some of the critiques, which I think are quite valid. And that law in itself may play a kind of kettling role in terms of confining political claims around migration, access to safe, regular migration, widening access to migration, in confining those to very predetermined legal forms with limited impact on structural change. And that could be seen as a critique, for example, of the narrow scope of a focus on human trafficking laws. And certainly in my work, what I'm trying to do is always highlighting the links across different parts of human rights law and different parts of migration law in particular, and the continuums of exploitation that lead to human trafficking, but of course are not limited to human trafficking as such. I think we also need to be very careful in discussions on human trafficking to avoid what David Kennedy has referred to as this excitement of the exotic, the abject victim, la noire, to quote from Ousmane Sembène, this focus of modern slavery and abject victims, which then trigger a rescue and humanitarian intervention as such. And there again, that is, in my view, leads to the problematic situation where the rights claimant is not seen as an agent or advocate on her or his own behalf. So trying to always move beyond what Diane Otto has called the injured subjectivities that are often produced in law's engagement with trafficked persons, in particular women. And then, of course, what's left out of that, the failure to recognize, acknowledge, and respond to the injured subjectivities of men and boys who may be victims of trafficking. So I would argue that the ideological capture of human trafficking law by this focus on rescue, on victimhood, on abject victims, the excitement of the exotic, that it's not complete, that human rights norms do have a jurisgenerative effect, to borrow from Sheila Ben Habib, that there is the possibility to produce new forms of public claim making, to anticipate new forms of justice. The risk, of course, is that the response is the enactment of exceptions, exclusions, and limits, the so-called de-juridifications, which exclude some from access to rights, access to remedies. And here, I think in particular, we can think about the intersections with underpinning racism and the failure to apply the non-discrimination principle to wider forms of punishment, including in the context of deprivation of citizenship. So that's all I wanted to say for now, and I'm happy to take any comments or answer any questions. Thank you.
Thank you so much, Professor Mullally. This was highly interesting. I really enjoyed your lecture, and I fully agree with your comments, especially on the need of expansive interpretations, both in terms of how we interpret what's punishment and also how we interpret the prohibition of non-punishment. Otherwise, as you say, the effectiveness of the principle will be limited. I would like now to open the floor to anyone who wants to raise any comments or questions. As you've seen, you have two possibilities. You can raise your hand or you can write your questions in the discussion box. I don't see any questions at the moment in the chat, but yeah. I see Isabel's hand raised.
Hi, Niobe. Hello, Siobhán. That was wonderful. That was a really great talk, and I learned a lot. I'm very interested in the UN's counter-terrorism global strategy, And I've spent quite a lot of time looking at the Special Rapporteur for the protection and promotion of human rights while countering terrorism. And I just wanted you, to ask you to sort of expand on the collective action perhaps by the Special Rapporteurs, and whether you've worked with that mandate as well, and whether other mandates will get involved in the counter-terrorism sort of situation as well. Thank you.
Thank you very much. Yes, absolutely. The communications to 58 states was led primarily by the Special Rapporteur on human rights in the context of counter-terrorism, Fionnuala Ní Éileán. And my mandate, and I worked very closely with her on those, in particular to bring in the situation with regard to victims of trafficking and the failures to identify, for example, detainees in northeast Syria as potentially victims of trafficking, and the children who are detained there also as a result of failures of states to repatriate or provide consular assistance, and then the consequences of deprivation of citizenship. So yes, we've been working very closely on that. Also on my non-punishment report and in the upcoming report to the General Assembly. And we're hoping to do some more joint work together, possibly linking into the Security Council if we can, and sort of building on Ireland's from Galway. One of the, I think, potential benefits is that bringing in the trafficking framework brings in a whole different set of actors and a different normative framework that has sometimes been missed. And we have, and as I mentioned, there are several references now to trafficking in Security Council resolutions, and brief references to the nexus between trafficking and terrorism, also in the Secretary General's reports, in the work of the Special Representative of the Secretary General on Sexual Violence and Conflict. But it's not really followed through in terms of, well, what does that actually mean then in terms of the human rights approach, the human rights obligations engaged, positive obligations of identification, assistance, repatriation, non-punishment. So it brings in a lot and adds quite a bit to that. All of those communications are now public. So they're on the website of the Special Rapporteurs. If you just click on communications and then click on specific mandates, trafficking, counter-terrorism, those all come up and you'll see the collaboration on those and the work on those. We're also looking at more cooperation in terms of amicus interventions in some of the case law that's pending at the European Court of Human Rights as well.
Thank you so much. I see a question from Professor Giles in the chat. Says, non-punishment is a very powerful framework. How have states reacted to or addressed the issue? Is acceptance growing among states?
Yeah, thank you very much, Elspeth. And I mean, we'll see. Actually, I think, I'm not sure that acceptance is growing yet, but I do think it is a powerful framework. And I think it sort of changes the debate a little. When it came up, it was just a brief note as part of a much more general report at the General Assembly last October. One of the responses was, well, you know, we need to keep a criminal justice focus and ensure accountability. But of course, that's neither here nor there with regard to the non-punishment provision. I think in practice, there's still a lot of resistance to the non-punishment principle. It looks like there's still a question as to whether the judgment of the European Court of Human Rights is final or whether it will be referred to the Grand Chamber. And again, the the resistance in terms of the application on the ground, you see in that litigation itself, the layers of resistance in practice, even though in that case it was children involved. So I think there is a sense, as you often see in migration law and also in trafficking law, that if that it may be a way of kind of escaping accountability, or a person who is in fact engaged in criminal activity sort of skipping a queue. So there's a lot of resistance around that, and that links to the kind of stigmatizing or stereotyping of certain groups also, I think, and there's clearly a gender dimension to that, and an underpinning racial discrimination element as well in many contexts. But I think it's an important normative statement. And if you look, for example, at the context of Shamima Begum, I think it flips it and is an important challenge to the criminal justice focus, the deprivation of citizenship, and instead to look at it from a child rights and a non-punishment perspective changes it quite a bit.
Thank you so much. I see Connie Raken has raised her hand.
Yeah, thank you so much. Thank you for the interesting talk, Siobhán. I have actually two questions, and it's to pick up on some of the points that you have made. And one is about also Greta's statements about the Dublin transfers during the reflection period. And there is now a case pending before the Court of Justice of the EU. It's a Dutch case where it's actually the question is raised whether the Dublin transfer are actually in line or a violation of the Directive 2004/81, where transfers are actually, or expulsions are prohibited. So that is one question. So how do you think about it? But also, what was also in this case is that so it was a transfer to Italy, and there were concerns that this person was victimized, became a victim of trafficking in Italy. So already that fact, I would say, that could be a violation of the principle of non-refoulement. But I would very much love to hear your thoughts about that. Yeah. And the second question is actually, well, building a bit on the former question by Elspeth on the non-punishment and the relation with the forced criminality, the trafficking for forced criminality. So because I always have a bit of a trouble, well, getting my thoughts around that, how that exactly works. So where do you draw the line? That you can expect from a person to resist to commit crimes, and on the other hand, well, if there is put pressure on a person to commit crimes, then it falls under trafficking for forced criminality. So how can we actually draw the line there? So what can we expect in terms of resistance from those persons in this situation? And I'd love to hear your thoughts on that as well. Thank you.
Thank you very much, Connie. First, in relation to the Dublin transfers, I think Greta has been quite strong on this, and I think that's very welcome. I think it doesn't comply with the Council of Europe Convention, obligations of identification, assistance and protection in relation to where the person is. And as you said, then it also raises the question of refoulement happening. And this was something when I was a member of Greta that arose in the context of an attempt to bring Rule 39 procedures in relation to a potential transfer from Sweden to Italy of a Nigerian woman and her young daughter, even though she had been identified as a victim of trafficking already in Italy. So I think that's very welcome that it's before the Court of Justice in particular, and it will be interesting to see how it plays out but I think it's, and I know there is the kind of savings clause in the Council of Europe Convention that was part of what was argued, that it may not be so relevant, but I think it engages so much of the obligations of identification, assistance, protection, recovery and reflection, all of that, that it undermines that. So it will be really interesting to see what happens. On the forced criminality, and I didn't touch on the whole question of when, what is required, what are the requirements for the application of the non-punishment principle. I have included it in my report to the Human Rights Council, but there I think Greta and others, the EU directive, all of that, they talk about the, you know, offences that are a consequence of being trafficked, rather than requiring the direct compulsion element as such. And that, of course, requires that there is recognition of trafficking, that there is identification, that there are trained, qualified persons, that the exercise of prosecutorial discretion is such that that is recognized. And, you know, to use the language of the European Court of Human Rights, the many subtle forms of coercion are recognized also. But there is now, you know, there is plentiful legal authority, I guess, on that, and it looks as at that, the offence being committed as a consequence of the trafficked person's subjection to trafficking, and that's fact specific, context specific, but it must be looked at along with the positive obligation of identification, assistance and protection. But there, I think, is where you see the resistance, if you like, in practice, and there you're most likely to see the gaps in implementation, I think. And that's all the more so than if you're talking about serious criminal offences. But there, I think, is where we also often see discrimination elements and discriminatory practices creeping in, where there's a reluctance to recognise the person as a victim because of their association with a particular group. But it's precisely in the practice, in that way, in interpreting and applying that, that is where the challenges are going to be. But I think Greta has also been quite strong on that in terms of the normative standard and examining the practice as well. Yeah, thanks.
We have a few more questions in the chat. One is quite extensive. So it says, thank you, Professor. Thank you, Madam Rapporteur. With the withdrawal of international forces from Afghanistan, the situation is rapidly evolving, and there are already new population movements both within Afghanistan and towards the borders with neighboring countries, especially Iran and Pakistan. The movements are linked with conflict, and as usual, risk of trafficking and smuggling are significantly overlooked by other security and political considerations. Has there been any study, risk analysis, list of recommendations to the government of Afghanistan or other governments, either by your office or other bodies? That's one.
Thank you very much. I think that's
Sasan Morares from UNOETC. Sorry.
Okay, thank you very much, and thank you for the question, and I'd love to talk about it with you more. I think it's a very serious concern. It has been highlighted by some states, but not, and agencies on the ground, but the risks are huge. They're not new either. The conflict in Afghanistan has been going on for decades now, and the consequences on the neighbouring states. And I lived in Peshawar for quite a while in the 90s, so I'm very familiar with the situation and the context, but I think it is an extremely worrying moment now, given the instability, the targeting that we have seen repeatedly of girls schools, the gaps in child protection, the targeting of human rights activists and advocates, but the risks of trafficking for the purpose of labor exploitation, forced criminality are huge, and the protection systems, mechanisms are not there. And the consequences, as you say, in the neighboring regions, in the border regions, where there is also already significant instability and conflict in Balochistan, in Waziristan, for example, in Khyber Pakhtunkhwa on the borders. So it's a very worrying situation. And I think the risks are very significant. And I'm not sure that the withdrawal is fully taking account of the heightened risks that will arise in those moments of instability. Thank you.
Thank you so much. I have received from Elspeth two further questions directly, so I will mention them at this point. So you mentioned amicus in Strasbourg, but are you as a special rapporteur also planning to intervene in the treaty body proceedings? And secondly, is UPR turning out to be a useful procedure for promoting the new non-punishment framework in the trafficking context?
In relation to treaty bodies, yes, I've engaged, as I said, with all of the treaty bodies in terms of, I've met with all of them. I've made submissions on draft general recommendations of the CRC, Committee on Migrant Workers, CERD. If there are communications or complaints arising, I have indicated that my mandate would be keen to engage and submit an amicus intervention. The difficulty is just sometimes tracking that. And there, really, we are very reliant on being informed of upcoming situations, complaints to treaty bodies. So to give you a picture, my mandate, which is global, is supported by 1.5 staff members in Geneva. So that's covering everything. So it's really critically important then just to have engagement from civil society, NGOs, lawyers, to bring things to our attention in a timely way that we can intervene. In relation to UPR, I think it potentially is a useful way to highlight the non-punishment obligation. But again, it would be very much dependent on trying to get, I think, states to do that and others to do that, to take it up, because the scope of the mandate is so limited in terms of just the resources to function in that way. But it's providing the resources for others, hopefully, to be able to take it up and engage in that way. And then, of course, the country visits and the country reports are a way to go into much more depth, but they are focused just on one country situation, of course. Yeah.
Thank you so much. Amy Weatherburn has posted another question in the chat, which says, your predecessor ended her mandate with a call to update the international trafficking framework. And there is a discussion of revising the EU Anti-Trafficking Directive in relation to the criminalization of the use of services of a trafficked victim. Given the lack of explicit reference of non-punishment principle in Palermo Protocol, where do you see the current status of international regional anti-trafficking framework? Do you think that we need to focus on better implementing what we have, or should we be looking towards an update?
Yeah, thank you very much. This was something that Maria Grazia Giammarinaro was really keen to push, that the Palermo Protocol is so limited. The obligations on states are so weak in terms of the protection of the human rights of victims, that we need a much broader and more comprehensive legal framework. My concern would be that so much time would be taken up in that, and that actually you have several international human rights treaties through which you can ensure the enforcement of the non-punishment principle and other human rights obligations by really reminding CERD, CRC, Committee on Rights of Persons with Disabilities, to really ensure that they are incorporating these obligations within their work. It would be, in an ideal world, yes, there would be a new comprehensive treaty that took account of jurisprudence, of case law, of practice, of human rights developments across the work of treaty bodies and special procedures and regional bodies. The Inter-American system has been particularly important. As I mentioned a few times, the African Committee on the Rights and the Welfare of the Child. But I think the time taken on that would just divert attention, resources away from trying to move now to ensuring that human rights treaties and existing standards are implemented in a way that gives the most effective protection and interpreting and applying existing standards. And yes, the developments at EU level are of interest, and you may have seen this whole series of events going on this week organised by OSCE on the subject of demand and combating demand, which has been linked to criminalisation, not just of the services, inverted commas, of a trafficked person, but sexual services more broadly, and also in the context of labour exploitation. So that is an ongoing discussion. There's a joint event. France and Sweden now have an alliance in terms of foreign policy in promoting what is referred to as the Nordic model, but the criminalization model in relation to sexual services. So they have a joint event coming up linked to the upcoming Human Rights Council. And a number of other states may be joining on that. So it's certainly gained momentum. Yeah.
Also, we see the hand of Virgil Yilmaz. Do you want to speak?
Hi, hello. Thank you for this amazing presentation. I've been working with refugee children and unaccompanied children in Greece. And recently, I've just completed a paper on how this figure of the child is defined in CRC, and when it's implemented on the ground, I mean, through, for example, procedures of EASO or IOM or Dublin, that this figure of the child becomes a suspicious figure where kids are subjected to medical and psychological tests and these kinds of things, and pushed towards irregularity, possibly including trafficking. So I was wondering, as these texts, these definitions travel, I mean, I'm a sociolinguist, so I call this process an intertextualization process. This figure of the child that is defined in these treaties completely change. So I was wondering if, I don't have any law background, so I'm a linguist. I was wondering if you have any comments on that, how this child is defined in the treaties, and you know how it gets complicated on the ground.
Thank you very much. Yeah, I think what we see is that what should be the kind of letter of the law or the text of the treaties in terms of protection, the core principle of non-discrimination, that is not applied in practice equally to migrant children, refugee children, children who are victims of trafficking. To take the AN and VCL cases before the European Court of Human Rights, they were Vietnamese boys, so had to go all the way to the European Court of Human Rights to vindicate their rights to non-punishment. So that's where we see the underpinning racism, limiting the application of human rights norms and obligations of non-punishment in the trafficking context, but also obligations of identification, assistance and protection, because they are not seen as children with rights to protection as such. I do think maybe to go back to Elspeth's point around the non-punishment principle as being a strong normative framework, that it is being referred to, for example, in the reports of the Special Representative of the Secretary General on violence against children, on children in armed conflict, emphasizing their rights as children, and in the context of trafficking as victims of crimes, with then the obligation to ensure child protection or access to other forms of protection, and the implementation of youth justice measures rather than a strict punitive criminal justice response. But yeah, I think that is and it's been highlighted within the Council of Europe in particular by the European Committee on Social Rights. And I think also by the Court of Justice, what we see is this failure to ensure the protection of the migrant child as a child as such in international law. But the CRC, Committee on the Rights of the Child, has a number of cases and decisions on this, as well as concluding observations, joint general comments also with the Migrant Workers Committee. But the practice, as you say, it's quite different on the ground, but that's where we see a failure in practice, not necessarily in the text of the law as such.
Maya?
Yeah, thanks, Niovi. And thank you, Siobhán, for this really super interesting talk. So this may be quite a specific question, but I'd be very interested in, I suppose, like the hierarchy of norms when it comes to exclusion from refugee status. So where a trafficked person who then claims refugee status has been involved in trafficking herself. So would you say that exclusion takes precedence, or does non-punishment? So how would you think that this should be resolved?
Thank you very much. So, and I think that's where the non-punishment principle applies, where and this is quite often the case, involvement in trafficking as a perpetrator, if you like, if that is a consequence of being a victim of trafficking. So if it is compelled in some way, then non-punishment is the core obligation as such. And it's establishing that and recognizing that and ensuring that a form of punishment that includes exclusion from refugee status is not happening, is not being applied, because that would be in breach of the non-punishment principle. But the difficulty is, yeah, ensuring that that is identified, recognized as a consequence of being a victim, where that is the case, then the non-punishment principle applies. But that's the specific context. Yeah. Is that answering the question?
Yes, very much so. Thank you so much.
Thank you so much, Professor. This is, I don't see any other hands at the moment. Is there anyone else who would like to take the floor or pose a question? In the meantime, I do have one question for you, which has to do, yeah, you are going to present now the report in the EU on the Human Rights Council. Would you like to share with us more about what are your priorities for the next year, perhaps COVID permitting or non-COVID permitting?
Sure. So the presentation to the Human Rights Council is scheduled for 28th of June. There is a side event then taking place on the 30th of June, which will focus on the non-punishment principle, but a range of perspectives on that. There is an interesting event, as I said, more broadly on the UN special procedures and collective responses that will take place next week, 22nd of June. In relation to the remainder of the work this year, the report to the General Assembly, which will be presented in October, but has to be completed in the next few weeks, is looking specifically at trafficking and conflict situations, and in the context of terrorism, counter-terrorism, armed groups, and questions around access in humanitarian settings as well. So that'll be the main focus in the early autumn. October is also Women, Peace and Security Month. So we're hoping to highlight the links there between trafficking and conflict situations, and perhaps to do some more work jointly with the Special Rapporteur on Counter-Terrorism, with the SRSG on sexual violence and conflict as well. The other main activity should be the country visits. There were two actually planned, one to Mexico, which has been postponed several times, and one to Bangladesh. The visit to Bangladesh being to really focus in on questions around supply chains, and also the displacement of Rohingya refugees, and risks of trafficking there also. It's unclear yet whether that will be possible, but ideally those should take place. A country visit is about 2 weeks. You have to get the permission of the state, so there are lots of requests pending, awaiting responses, and it's interesting to see how difficult it can be actually to get states to accept the request for a country visit. It's not straightforward, so it requires meetings and discussions around that. And other than that, work is ongoing in a range of communications, including in particular on issues around labour migration, and migrant workers particularly at risk. And we are also concerned to continue to document and recognise the impact of COVID-19 in terms of access to assistance, to shelters, situations where we've seen closure of borders, pushing people into more risky situations, where curfews have been implemented or lockdowns, that may mean that some people are at heightened risk of exploitation. And then of course with difficulties in informal economies, rising unemployment, again pushing people into situations of poverty where they may be at greater risk of exploitation.
Thank you so much. You definitely have a lot on your plate, and this is all very, very exciting. So I don't see any other hands or any other questions or comments in the discussion box. So without further ado, and with apologies for the lighting in my room, it has been horrible, I know, I will end this session and the recording, and I wish we were in person to join in congratulating and on your mandate and on your wonderful lecture. And I would like to thank you so much again for accepting the invitation and this wonderful lecture that you delivered to us, and for explaining all the terrific work that you have been doing and you will continue to do. Thank you all so much. Have a great evening, and hopefully we will meet soon in person as well. Goodbye.
Thank you very much. Thank you. Bye-bye. Thank you.